Hi guys, welcome to Learn Kenyan Law with Wanjiku, and as you know, this is the channel where you get legally informed, especially matters law. So for today, we're going to be talking about the rights of an accused person. So of course, who is an accused person? An accused person is someone who's been arrested and they've actually been accused of doing a specific crime. Maybe they're being said to have robbed with violence. Maybe you're being charged with robbery with violence. So what are your rights here in Kenya when you've been accused of committing a crime? It is very important for us to note that under Article 50, subsection 2 of the Constitution, it is very clear that an accused person has a right to a fair trial. And of course, when you're talking about these rights of an accused person, it basically covers the area around a fair trial. However, it is not exhaustive. And of course, Article 25 states that there is no limitation on this specific right. So let me mention these rights and then we're going to delve into them deeper. You have the right to be presumed innocent. There are rights connected with preparation of a defense. There are rights to public trial. You have a right to an expeditious trial. You have a right to be present. You have a right to an advocate. And you also have a right to remain silent. There are rights to evidence. There is a right not to incriminate yourself. You have a right to an interpreter. There's the principle of legality applies as well. There's the right to protection from double jeopardy. There's the right to the least severe punishment, and you have the right to court records. So now let us delve deeper into it. And we're going to be starting with the right to be presumed innocent. Of course, when you're being arrested and when you're being accused of something, you're considered to be innocent until proven guilty. And especially if it is a criminal case, the burden of proving your guilt lies solely on the prosecutor. So you as the accused person, you can basically just go to court, take a seat and let the prosecution prove their case because you're presumed to be innocent at that particular time. The next kind of rights that we're going to be talking about are rights connected with preparation of defense. So here, the most important thing to note is that you as the accused, you have the right to be informed of the specific charge that you're being accused of and with sufficient detail to answer it. So let me give an example. For example, you're being accused with robbery with violence. You have to be informed, where did you rob? Who did you rob? What did you take when you robbed them? You need all this kind of information so that you're able to prepare your defense in a very comfortable way. Another important thing to note is that when I say you have the right to be informed, I also mean that the information has to be conveyed in a language that you understand as an accused person. So for example, you're a Kikuyu, you don't know English, unfortunately, and you've been accused of something. The information that you're supposed to be given should be in a language that you understand. So for example, the police officer should be able to talk with you in Kikuyu and tell you, you know what, you're accused of robbery with violence, and you took this, and it happened on this and this day. The police officer should give you the sufficient details in terms of the specific charge that you're being told, but with a language that you as an accused understand. Another important thing to note is that this information should be in a format that is accessible. For example, you're blind and they want to inform you of the specific charge that you're being accused of. They should be using a braille. For example, you're deaf and you're being accused of robbery with violence. Of course, this information should be in an accessible form, which means that a sign language interpreter should be there to, inform you of this specific charge so that you're able to answer it. And of course, when we're talking about rights connected with preparation of a defense, is that as an accused person, you must be accorded enough time and facilities to prepare a defense. So if again you're being accused of robbery with violence, you've been accused today, then there's no way the court proceedings will start tomorrow. Of course, because you need enough time and facilities to prepare a defense. And that is why sometimes you go to court and the lawyer is going to ask the court, please add me more time so that I can be able to investigate this matter deeper so that it does not prejudice the accused. So when you're talking about the rights connected with preparation of a defense, you have to be informed of the specific charge with the sufficient details to answer it. And of course, you must be accorded enough time and facilities to prepare a defense. Let us go to the next right, which is you have a right to a public trial. Again, if you're an accused person and of course you're being accused of robbery with violence, the press or the public can be included. You have a right to a trial which is held in public. Your mother should feel free to walk in a courtroom and listen to this case. However, this right to public trial is not applicable to everyone, especially when it is about vulnerable persons. For example, if it is a case about a child, the press is going to be excluded and the public may also be excluded. if it is a case about morality, if it is a case about public order, or rather if it is even a case of national security, the press and the public may be excluded. But if it is just a normal individual, you're being accused with robbery, with violence, your mother should be allowed to come and sit to court and listen to the whole proceedings. Let us go to the next kind of rights that you're going to have. You have the right to an expeditious trial as an accused. Basically, when I'm talking about the right to an expeditious trial, I mean that this right should be concluded without unreasonable delay. If there is delay, it has to be reasonable. If it is unreasonable, then they're tampering over your rights. So you have the right to an expeditious trial as an accused person. The next kind of rights that we're going to talk about is that you as an accused person, you have the right to be present. Basically, you have to be present during the trial. If you're being accused of robbery with violence, you have the right to sit at the courtroom when your case is being heard, unless you as the accused person, you have a conduct that makes it impossible for the trial to continue. Maybe you're an accused person and you go to court and you start insulting everyone. Then you no longer have these rights because the court cannot continue trying you. The trial cannot proceed because of your conduct. Maybe it's you're there insulting people, interrupting everything. Then the trial cannot proceed. However, if you conduct yourself in a civilized way, you have the right to be present during trial. The next kind of right that we're going to be talking about is the right to an advocate. And there are two aspects to this. The first is the right to have an advocate that is not at a public expense, meaning you are the one paying the advocate privately. The public or the state does not pay for that advocate. And then the second one is the right to have an advocate assigned to you by the state. And mostly, the state assigns an advocate for you if they sit down and realize this will if you go to court without an advocate, it might cause a substantial injustice. So sometimes the court is compelled to just make sure you have an advocate, because if the case goes on without you having an advocate, it might cause a substantial injustice. And of course, another important thing to note when you're talking about a right to an advocate, in the case of a child, the court must order that the child must be granted legal representation. So if the accused person is a child, the court has to order that this child has to have a legal representation. The next kind of rights that you're going to be talking about is that you have the right to remain silent. And of course, when we were talking about the rights of an arrested person, an accused person as well has the right to remain silent. As an accused person, when you go to court, you can decide you don't want to testify and it shall not be held against you, And of course, you can also decline to answer some specific questions, especially if you feel like they're going to incriminate you. So you have the right to remain silent, and you remaining silent does not either add anything to that trial or subtract anything to that trial, because it is your rights. The next kind of right that we're going to be talking about is the rights to evidence. And basically, you as an accused person, you have a right to be informed in advance of the evidence that the prosecution intends to rely on. So an example, you're being accused of robbery with violence, and the prosecution intends to rely on a knife that they found on the scene. You have to be informed prior. You should be given this evidence within a reasonable time so that you're able to also prepare your defense. They have to tell you, by the way, we are intending to use the evidence that we found there, which is the knife that has the fingerprints of the accused person. They have to tell you this in advance so that you're able to prepare your defense in a right way. And also, when it comes to the right to evidence, you also have the right to challenge any evidence that is presented against you. So if the prosecution is using this knife and they're saying that you indeed went and robbed these people, and the knife was found there, and maybe you visit them, you have the right to go and say, you know what, last week I was here and we were having a party and I had to come with my knife because we were grilling meat outside and they did not have a sharp knife. You have the right to challenge any evidence that the prosecution is using against you. And of course, you also have a right to present your evidence. So basically, if it is still robbery with violence and they are saying that, you know what, you robbed these people on August 2nd, and unbeknownst to them, you had traveled to Kitengela on August 2nd, and you even have receipts, transport receipts to show that indeed I actually even used the train to get there, and luckily I have the receipt. As an accused person, you have the right to present the evidence in defense. The next right that we're going to be talking about is the right not to incriminate yourself. As an accused person, you have the right to refuse to give any self-incriminating evidence. Of course, why do you have this right? Because there's the right that this right resonates with the presumption of innocence, you know. So according to the first right that we talked about, you're presumed innocent the minute you're accused of something, you're innocent. So you have the right not to give any evidence that is self-incriminating. And again, it is the prosecutor's duty to prove your guilt beyond reasonable doubt. So this is your right. You don't have to say anything that might be incriminating to you. The next kind of right that we're going to be talking about is right to an interpreter. As an accused person, in case the trial proceedings are held in a language that you do not understand, maybe you do not understand English and you all your life you've only spoken in Kiswahili, the court has to grant you an interpreter who shall interpret English to Kiswahili. If you do not speak maybe English and you don't even understand it, the court has the right to give you an interpreter to the language that you understand. Again, if you are deaf, the court has to give you a sign language interpreter. And of course, it's very important for us to note that this specific right also applies even to the accused person's advocate. Meaning, in case the advocate does not understand a specific language for personal reasons, the advocate should also be provided an interpreter so that the advocate can understand the trial proceedings. And it is also important to note that if the evidence is given in a language that is not either understood by the advocate or the accused, an interpreter must be granted so that both of you can understand what is happening in the trial proceedings. The next kind of right that we're going to be talking about is the principle of legality. And basically, the Constitution provides that a person should not be convicted for an act or omission that was not an offense, neither under the Kenyan law nor international law. So basically, if you go do something, and by Kenyan law it is not an offense, and even under international law it is not an offense, then there is no way you can be accused or even sentenced for that specific crime. Again, it is important for us to note that if you are being accused on an offense that is not an offense under Kenyan law, but it is an offense under international law, then this right does not apply to you. You can still be convicted. However, if you have committed an offense that is not an offense under our Kenyan law, and it is also not an offense under our international law, then you should not be accused. You should not even be serving any sentence. Your case is over and done at that particular point. That is what we mean when we talk about the principle of legality. The next kind of right that we're going to be talking about is the right to protection from double jeopardy. An accused person may not be convicted for an act or omission that they were previously either acquitted of or convicted of. So basically, if I was convicted of robbery with violence and I actually even went to prison and served my 5-year term, then there is no way I can be taken to court again and be tried for the same specific offense that I was convicted of. Or rather, if I was also acquitted of a specific crime, you know, maybe the court acquitted me from all those, the specific crime, then there's no way I can be taken to court like 10 years later for a crime that I was already acquitted of. However, if the trial was aborted, you know, if the trial was aborted and me as the accused, I was discharged, but I was not acquitted and I was not convicted, then even if it is 10 years later, a charge on the same facts could be brought. So when we're talking about the rights of the rights to protection from double jeopardy, we basically mean if as an accused person you're either convicted or acquitted of an act or omission, then there is no way you can still go back to court for the same kind of trial. However, if the trial was aborted, then years later I can still go to court and face the same charge that are on the same facts that were brought. So the next kind of right that we're going to be talking about is the right to the least severe punishment. So basically here we mean that where the sentence for an offense has been changed between the commission of the offense and the time of the sentence, the accused is entitled to the lesser sentence. Let me give an example. You're being accused of robbery with violence. The trial has already begun and it is February 2022 and it has been continuing and continuing. Then, on March 2022, Parliament decides that they need to increase the time of sentence when it comes to people who are being charged and convicted on robbery with violence. And they say, you know what? Let these people go in for 30 years. You know, there's a lot of robbery happening. Let us increase the sentence. But you see, you were captured on February. The law changed on March. You, as the accused person, you have the right to the least severe punishment. So even when your trial is continuing, you should indeed serve the 20 years that were there when you were caught on February 2022. That is what we mean when we say that an accused person has a right to the least severe punishment. The next right that we're going to be talking about is that as an accused person, you have the right to court records. What do we mean by this? Basically, as an accused person, you're entitled to a copy of the records of the court proceedings on request. So if you request for the court proceedings and you actually even pay a fee if you need to, it is your right to get the court records. However, this right does not extend to persons charged with an offense that the court may try by summary procedures. So if the court has tried you on summary procedure, then you don't have the right to go and request for court records. But if it is not that, then you have the right to go and ask for a copy of the records of the court proceedings. So basically all those are the rights of an accused person here in Kenya. Thank you so much for listening to this end. In case you have a question, feel free to ask. Any comment, feel free to comment. In case you want to reach out, do the same. Feel free to subscribe so that you can continue understanding our Kenyan law. Thank you guys. Bye.